It is a great pleasure to address you here today at the end of your summer school. And I was also quite surprised, but very happy to see that there actually is summer here in London, because I came from the Netherlands today, and in the Low Countries, we do not have any summer yet. But I understand that over the past few days, you have been discussing arbitrations of several flavors of different kinds, and from a number of different angles and perspectives. Territorial disputes are disputes over territorial title under international law, and over boundaries that delimit those territories. And they mostly arise in relations between states, although there are some exceptions to that, as we will see. But the legal framework of territorial disputes is therefore public international law. My take on arbitration will also be from the public international law perspective. But I will also argue that even in public international law, arbitration in many respects follows certain private law patterns. And I will now focus on two main issues. So first, the place of international arbitration as a method of peaceful settlement of territorial disputes within the broader system of international dispute settlement. And secondly, on the question of how arbitral tribunals address, or sometimes don't address, territorial disputes where these disputes appear as an incidental question in another dispute. To set the scene, I will begin with contextualizing arbitration within the broader landscape of international dispute settlement, and then focus more specifically on the role of arbitration in it. In public international law, any dispute settlement organ has to be created by an international treaty. And the jurisdiction of this organ is then also created or regulated by that treaty. And already here we bump into some private law principles. Namely, treaties work on the basis of contractual logic. Some languages indeed don't even have separate words for treaties and contracts. And already this points to the fact that we can effectively think of treaties as a system of contractual obligations between states. And we know from the basics of contract law that they only bind parties. The same logic then applies to states and treaties. Treaties aren't binding on all parties. And because of the treaty law environment, international dispute settlement then depends on consent of states. Although there are different ways, different modes of expressing consent, but we have state consent in the background before we can have any kind of international dispute settlement. In order to have any dispute settlement in public international law, states must have first created an adjudicatory body by a treaty, and the relevant state must have signed up for these procedures. And in public international law, then we distinguish between dispute settlement mechanisms with compulsory and those with non-compulsory jurisdiction. Jurisdiction is compulsory, where merely being a party to a certain treaty that creates the dispute settlement mechanism counts as an expression of consent to dispute settlement. Notably, the WTO system has such a compulsory mechanism, but it still, of course, requires that the WTO agreement is ratified. So state consent at this stage is still needed. But with non-compulsory mechanisms, merely being a party to the treaty that creates a certain adjudicatory body and its procedures isn't also an expression of consent for dispute settlement. In other words, a state may have consented to the creation of an adjudicatory body, but this consent is not necessarily also consent to be subjected to jurisdiction of this body. The modes of expressing consent then depend on the adjudicatory body and the exact procedure in question. But it is quite common that an adjudicatory body would have jurisdiction where parties, by mutual agreement, refer a particular dispute to a one-off settlement procedure, or where an international treaty contains a so-called compromissory clause. This means that the treaty specifies that should there be any dispute under this treaty in the future, a certain adjudicatory body, a certain mechanism would have jurisdiction to hear that disputes. And states thereby agree to future dispute settlement when they become parties to the treaty that contains this compromissory clause. But the jurisdictional scope of the adjudicatory body is then limited to the scope of that treaty. It is not then, there is no jurisdiction over public international law in general, but only its jurisdiction is limited to the scope of that treaty. So now to sum up this preliminary part, in order to set the scene properly, in public international law, we don't have a public law system of courts with compulsory jurisdiction that we know in municipal legal systems. We are operating in a treaty law paradigm. And because treaties work on the basis of contractual principles and are underpinned by party consent, international dispute settlement depends on state consent and whether states have made relevant treaties and signed up for certain dispute settlement procedures under these treaties. And the result is then that international remedies may often be very limited and quite often also not available at all. And in the context of international dispute settlement, we then need to distinguish between courts and arbitrations. But even with courts, we need to know that they do not operate quite like domestic courts. They are still state consent dependent and driven by state consent, and as such, in many respects, operate on private rather than public law principles. Now, focusing on arbitration, the central umbrella institution for public international law-based arbitral proceedings is the Permanent Court of Arbitration in The Hague, which shares its premises in the Peace Palace with the International Court of Justice, the ICJ. These are two separate institutions and also quite different in nature. The ICJ is an organ of the United Nations and is a court in the sense that it has a permanent bench, but its jurisdiction isn't compulsory. On the other hand, the PCA, the Permanent Court of Arbitration, dates to 1899. It predates the UN and the UN's predecessor, the League of Nations, and is actually not a court. And it was just last week, there are big celebrations to mark the 125th anniversary of this institution. So, but because it is an institution that is 125 years old, the name Permanent Court of Arbitration is a bit misleading. So it is not permanent in the sense of permanent bench, and it is not actually a court. It is an administrative body that logistically and administratively facilitates the formation and the work of arbitral tribunals. It does not have a permanent bench, as I said, and the tribunals are set up on an ad hoc basis. And the name, the misleading name, I think probably reflects the era in which it was created, before any real international court existed. I sometimes say that the name reminds me of a guinea pig, right? So Permanent Court of Arbitration, neither permanent nor a court. But the idea was to create a standing institution which would facilitate dispute settlement and provide for some standardized optional procedural rules and a list of potential arbitrators. And now if we look at the arbitral awards that have been rendered under the PCA auspices, we see an interesting pattern. we see quite some case law in the first 20, 25 years of its existence, and then virtually nothing for decades. Why is that so? Because after World War I, the Permanent Court of International Justice was established in The Hague. That was the forerunner of today's ICJ. And then in the 1920s, disputes started to be referred to that institution, the real court with permanent bench. So the PCA for the in the interwar period and then in the Cold War period appeared to be of more historic than contemporary relevance. But then in the 1990s and early 2000s, things started to change. And arbitrations under the PCA auspices became much more popular again. Why is this the case? Well, one thing is that if we look at the identity of the parties in the proceedings, we see that sometimes disputes brought to arbitral proceedings could not be brought to the ICJ for procedural reasons. Namely, the ICJ only hears disputes between states. But nowadays, the international system is much more inclusive than that was the case historically, and non-state actors started to play a much more prominent role. The arbitral rules are much more flexible in this regard and allow for participation of certain non-state actors, as evidenced by a growing number of investor state arbitrations, for example. With regard to the identity of the parties, a very interesting dispute was brought to the proceedings under the PCA umbrella, which was the Abyei arbitration, a territorial dispute concerning the limitation between Sudan and Southern Sudan before South Sudan became an independent state. Since South Sudan had not been a state at the time, there was no access to the ICJ. But the idea was to settle the territorial question prior to independence of South Sudan. And the PCA optional rules were used for arbitration where only one party is a state. And the arbitration rules allow for that, while the ICJ statute does not. In this vein, it is also interesting to recall that arbitral tribunals have been set up on the basis of international arbitral principles, also to settle internal boundaries where no subsequent statehood was in question. For example, between Swiss cantons and Canadian provinces. So we can see that sometimes even purely internal disputes, purely internal territorial disputes are resolved in arbitral proceedings. What is perhaps even more interesting is that looking at the identity of parties, one can also notice that sometimes even classical interstate proceedings go to arbitration rather than the ICJ. The main generator at the moment of such interstate arbitrations is UNCLOS, the United Nations Convention on the Law of the Sea, an annex to which contains a complex dispute settlement clause. And this clause provides for a cascade of dispute settlement mechanisms, so a combination of courts and arbitral tribunals with arbitration as default setting. So then this complex dispute settlement mechanism makes UNCLOS quite a unique treaty and a generator of arbitral proceedings. And while arbitration is the default setting under UNCLOS, its dispute settlement rules make it clear that only disputes under this convention, so under UNCLOS itself, may be referred to dispute settlement procedure. So the jurisdictional scope is UNCLOS, not public international law as a whole. But it is further possible for states to a bit narrow even further the scope of jurisdiction and inter alia reserve against disputes concerning sea boundary delimitation. And this then limits the number of territorial disputes that can be brought to arbitral proceedings following this avenue. A very interesting case was the Philippines-China South China Sea arbitration, where China had such a reservation, so an exclusion of sea boundary delimitation. But the Philippines very carefully phrased its claims to arguably only ask the arbitral tribunal about the status of certain maritime features and not about the sea boundary as such. China then ignored the proceedings as it thought that was actually a delimitation dispute by the back door, and that the tribunal should not have exercised jurisdiction here. China's non-participation, however, did not stop the proceedings, as a mechanism is foreseen under UNCLOS that an arbitral tribunal is established, even if a party chooses not to participate. So non-participation cannot halt the proceedings. The tribunal that was then established and very formalistically distinguished between the status of certain maritime features and the consequences this status had for sea delimitation. Opinions on this approach are now divided. In the strict formalistic sense, the tribunal indeed didn't rule on the boundary, but its arbitral award could be interpreted as having indirect effects for it. Some commentators have also observed that China's non-participation might have backfired, and that had China challenged the arbitral tribunal's jurisdiction with strong legal arguments in the actual arbitral proceedings and not in fora politico, as it tried to do, so that this was a boundary dispute in disguise. So the outcome could have been different, but I suppose we will never know. Then there are certain interstate arbitrations also other than UNCLOS, the UNCLOS generated ones, where states by mutual agreement refer a particular dispute for a one-off settlement procedure. Such arbitrations are particularly interesting because disputes could be in principle referred to the ICJ, but parties choose arbitration instead. This is probably due to flexibility, which arbitration offers in comparison with the ICJ in terms of composition of the arbitral tribunal and the choice of law. If states bring a dispute to the ICJ, the court applies the formal rules of public international law under Article 38(1) of the ICJ statute, which is also a statement of the formal sources of international law. So treaties, customary international law, general principles of law, and then the subsidiary sources, such as judicial decisions and academic writings. But in arbitral proceedings, the parties can choose their law more broadly than that, if they agree to do so. There is no pre-existing treaty that would limit their mutually agreed upon choice of law. Now, to give you an example from the territorial dispute between Croatia and Slovenia, it involved two states, so it could have been referred to the ICJ, but the parties agreed to go to arbitration. What would be their motivation? Especially if we know that the ICJ proceedings are free of charge for UN members, while in arbitral proceedings, parties need to cover the costs of the arbitral tribunal. Now, if we look at the applicable law defined by the arbitration agreement between Croatia and Slovenia, we see that it went quite beyond the formal sources of law, which are applied by the ICJ, and this agreement between Croatia and Slovenia also included equity, good neighborly relations, and I quote, all other relevant circumstances. The applicable law needs to be read together with the tasks of the arbitral tribunal, which was not only to determine the land and maritime boundary in certain contested areas, but notably also to determine, I quote, Slovenia's junction to the high seas. So the task was not to determine whether Slovenia's junction existed in the first place, but to determine the junction. The arbitral agreement, therefore, defined the parameters of the dispute settlement quite differently, and I would also say much more prescriptively than this could have been done under the statute of the International Court of Justice. So arbitral proceedings were obviously chosen because the parties were more flexible in determining the parameters of dispute settlement, particularly the choice of law and the tasks of the tribunal. I will not go into the political reasons for making this choice, but the example proves the flexibility that parties have in arbitrations, and this may be an important factor why they may choose arbitration, why they may not go to the ICJ and set up an arbitral tribunal instead. But the arbitral nature of dispute settlement in Croatia-Slovenia territorial dispute led to another problem, and indeed perhaps to another dispute. As is well known, secret recordings had emerged which revealed communication between an agent acting for Slovenia in the case and the arbitrator of Slovenian nationality. Croatia argued that this communication represented a material breach of the arbitral agreement in the sense of Article 60 of the Vienna Convention on the Law of Treaties, which may be invoked as a ground of treaty termination. And of course, the arbitral agreement is a treaty of international law, so it is governed by the Vienna Convention. Slovenia admitted the wrongdoing, but argued that the treaty, so the arbitral tribunal, remains valid. Only the arbitral tribunal needed to reconstitute itself. And in support of this argument, inter alia, the competence or competence de la competence principle was quoted, which means that a judicial body has the competence to decide on its own competence, a general principle of law. In the end, the arbitral tribunal did reconstitute itself in a different formation, so this competence principle was followed and continued its work, and then rendered the arbitral award in a new composition. But Croatia goes back to the beginning and claims that the arbitral agreement no longer existed at the time under treaty law. So the arbitral tribunal did not have the authority to render the award. So put it simply, according to Croatia, the arbitral tribunal could not decide on its own competence because at the time it decided on its own competence, the tribunal actually no longer existed, according to Croatia. Now, without going into substantive details of treaty law, we can see that this line of argumentation, whether one agrees with it or not, is possible only where arbitral tribunals are concerned. This line would have been impossible to take in relation to proceedings before international courts. Why? Because an arbitration agreement also establishes an arbitral tribunal. So in arbitrations, we have ad hoc tribunals, while courts have permanent benches. If the arbitration agreement is invalid for whatever reason, there may be no tribunal. The issue is that the same source of law refers a dispute to dispute settlement and creates an arbitral tribunal. The legal authority for dispute settlement and the institution of an adjudicatory body then sit on the same branch, so to say. And arguably, we cut off the branch, the arbitral tribunal falls down too. But this is different with courts. They are created by separate foundational treaties, and even if something is manifestly wrong with the procedure in a particular case, this does not call into question the validity of the courts found in treaty and thus of the court itself. So the territorial dispute between Croatia and Slovenia has now become also another dispute, or has morphed also into a dispute over validity of the arbitral award. But is the argument of a cutoff branch tenable? Does a material breach of an arbitration agreement kill the arbitral tribunal? I think this is a deeper theoretical question, which takes us back to the nature of international arbitration. Is it of purely private, contractual-like nature between parties, or does it have a broader public function in the international community? Once an arbitral tribunal is established by an arbitration agreement, does such a tribunal then have its own legal life and severs the umbilical cord that connects it to the arbitration agreement and thus to the rules of treaty law? Or does it stay connected to that found in treaty and hereby remains dependent on the subsequent developments that may affect validity of this treaty? This leads me to a broader question. Whether and how do general principles of law and certain procedural principles that may have been developed before other judicial bodies apply to arbitral tribunals and arbitral proceedings? And here we can again draw from the disputes where territoriality was in the background. A very interesting dispute was an investor-state dispute brought under the PCA auspices, Larsen versus the Hawaiian Kingdom, in which the claimant alleged that the Hawaiian Kingdom was in breach of certain obligations because it unlawfully allowed the imposition of the US municipal laws in the territory of Hawaii, in violation of its obligations under the 1849 Treaty of Friendship, Commerce, and Navigation with the United States. Now, whatever we may think of the merits of this claim, the arbitral tribunal was here asked to make at least some implicit pronouncements on the rights and duties of the United States, which was not party in the proceedings, and did not give a valid consent to be brought to this investment state arbitration, which was in fact ancillary to the question on territorial sovereignty, on territorial title over Hawaii. When this case was brought to arbitration some 25 years ago, the ICJ's monetary gold/East Timor doctrine was already well known. I'll come to this in a second, but here I will say that, but East Timor was before the ICJ, while Larsen versus Hawaiian Kingdom was an investor-state arbitration. Nevertheless, the arbitral tribunal quite happily applied the ICJ-developed doctrine to declare that it could not exercise jurisdiction because the legal interest of the United States formed the very subject matter of this dispute, and the United States was not a party in the proceedings. Now, although different in many substantive respects, the case indeed had at least some procedural similarities with the ICJ's East Timor case brought by Portugal against Australia before East Timor was independent from Indonesia. At the time, East Timor was effectively governed by Indonesia, and plausible substantive claims could be made that Indonesia's territorial governance was illegal and in violation of the right of self-determination. But when Portugal brought the case against Australia, after the latter had entered into agreements with Indonesia on exploitation of certain resources around East Timor, the ICJ decided that although it in principle did have jurisdiction to hear a dispute between Portugal and Australia, it was unable to hear this particular dispute in the absence of Indonesia. Now, for the purposes of arbitration, it appears that the doctrine applied applied in East Timor by the ICJ has transcended the boundaries of the ICJ's body of case law and has become a general principle of international dispute settlement, or even where arbitrations are concerned. So it is not limited to the ICJ. So perhaps this indicates that arbitral proceedings don't run in an international legal vacuum, and certain general principles, especially those governing the procedure, are applicable even where they aren't explicitly mentioned in the arbitration agreement, so that we are moving a bit beyond this this strictly bilateral context in arbitrations. It may thus well be that an arbitral tribunal, once lawfully established, does to an extent sever the umbilical cord that connects it to its founding treaty, and its procedures are governed by certain general principles of procedure law and by international settlement. It certainly doesn't only happen in territorial. It certainly doesn't only happen in territorial disputes that legal interest of a state non-party in the proceedings forms the very subject matter of the dispute, and that the case cannot be heard as a result. But in practice, territorial disputes are prone to generating such situations. Why? Because parties often go forum shopping and try to bring a territorial dispute and adjudicatory body by the back door, where no jurisdictional link, no consent exists to bring the original dispute. So they try to sell it to an adjudicatory body as something else, as another dispute. And then they hope that the adjudicatory body would make at least some implicit pronouncements on the underlying dispute, to which the dispute they brought is ancillary. And the reason why such ancillary disputes are brought in international adjudication by detour is what I mentioned at the beginning: the consent-based system of adjudication based in international treaties. There may often be no consent and thus no remedy for the original territorial dispute, and then a party tries to take a detour. But then ancillary questions of territoriality can also appear where there is a mismatch between law and fact, where a territory is a part of one state de jure, but governed by another state de facto. This has happened in investor-state arbitrations with respect of Crimea. And here the arbitral tribunals took, I would say, a functional approach in certain cases, and treated Crimea as if it were a territory of Russia. But under public international law, Crimea remains a part of Ukraine, but then Russia is, of course, in effective control of the territory and has certain obligations under international law that stem from territorial occupation, however illegal this occupation may be. But Russia and Ukraine have a pre-existing bilateral investment treaty, and if you're Ukrainian with an investment in Crimea, do you, after the critical date in 2014, the date of annexation, fall under that bilateral investment treaty, BIT, as a foreign investor? So the question is, did the illegal annexation internationalize the Ukrainian investor in Crimea for the purposes of investment law, although it did not for the purposes of general public international? In the arbitral proceedings, as I said, it has then been indeed established that Crimea can be effectively taken as a part of Russia for these purposes. Now, is this right or wrong? On the one hand, under public international law, under the law of state responsibility, one shall not recognize any effects of territorial illegality. But on the other hand, the obligation, also under the law of state responsibility, isn't absolute where private rights are concerned. It would appear to be also wrong to leave the investors without protection because international territorial illegality has been committed in the place of investment. There is thus a tension between general territorial illegality under public international law and rights of private individuals. And the investment arbitrations have here upheld the right of private individuals while avoiding the question of territorial status of Crimea under public international law, which is, after all, an issue over which an investment tribunal doesn't have jurisdiction. The arbitral tribunals have thus followed a line somewhat similar to the one developed by the ICJ, the International Court of Justice, in the Namibia advisory opinion, with the so-called Namibia private rights exception. So even if territorial regime is illegal, certain sovereign acts of the illegal authorities still need to be accepted and accommodated in practice for the benefit of the population and of the affected individuals. Now, if I try to categorize, moving toward conclusion, it can be said that arbitral tribunals deal with territorial disputes in three types of situations. The first one is that when the dispute cannot be brought to a court, most commonly to the ICJ, due to procedural reasons. For example, at least one of the parties isn't a state, or the UNCLOS arbitration default kicks in. Secondly, the case could have been brought to the ICJ, but parties opt for arbitration because of greater flexibility that arbitration offers in terms of the choice of law and tasks and composition of the tribunal. And thirdly, there is an important category of territorial disputes that appear before arbitral tribunals incidentally in the context of another dispute. This third category could have two subcategories. One is where the incidental question on territorial sovereignty is genuinely incidental. And secondly, where a party deliberately reframes the territorial dispute as another dispute and hopes to find an adjudicator body that will exercise its jurisdiction, and in doing so, make at least some implicit remarks that are relevant for the underlying territorial dispute. And this happens because jurisdiction for dispute settlement is very, very limited internationally, and again, dependent on consent. Now, international dispute settlement under the procedures provided for by public international law reflects the treaty law background of such procedures, and with that, contractual logic. These procedures are based on state consent, but as I said, different modes of expression of consent are envisaged. The result is that remedies often aren't available. And this is not only the case with arbitral proceedings, but also with proceedings before international courts. There have been a number of situations where parties have tried to bring to dispute settlement a dispute that was ancillary to another dispute, but no adjudicatory body had jurisdiction to hear that original dispute. And territorial disputes are common generators of ancillary question. And I think this probably has to do also with fragmentation of international law, because dispute settlement procedures are more available in certain fields than in others. They're more available in international economic law, in the law of the sea, and with some geographic limitations in human rights. But this is not the case with general international law concerning territory and boundaries. And this is why then the questions of territorial sovereignty would appear as incidental questions, either genuinely or because the questions are strategically formulated, so in investment, law of the sea, or human rights cases. The current system of international arbitral proceedings and dispute settlement in general is thus rather imperfect and unbalanced. But it is a logical consequence of the consent requirement which comes with the treaty law framework. We do not operate within a proper public law paradigm, despite the name public international law, and a state-like judicial system. We operate within a contractual paradigm where even international courts look more like permanent or standing arbitral tribunals rather than proper courts as we know them in municipal settings. This creates then a tension between treaty law and this private law paradigm of international arbitration on the one hand, and the broader public function that arbitration ought to have in the international community on the other. Its function is also peaceful settlement of disputes. And we know that especially territorial disputes are the fiercest generators of international conflicts. It appears that despite this public and community-oriented peaceful dispute settlement function, international arbitration and international dispute settlement in general still haven't liberated themselves from their treaty law origins, and with that of the contractual logic on the basis of which international dispute settlement operates. But nevertheless, even in public international law, arbitral proceedings are governed by general principles of law, particularly those pertaining to the procedure. These principles then cross the boundary between the case law of courts and of arbitral awards. They are also part of the same international dispute settlement system, but as I said, the whole system in many respects appears to be more arbitral than judicial in nature. Thank you very much.